Good morning, everyone. Okay.
Good morning.
So if you're joining us this morning, this is a code compliance hearing for the City of North Miami. Today is January 26, 2023. My name is Beatrice Gezo, Special Magistrate for the City of North Miami. The purpose of this hearing is to determine if a code violation exists at your property, as observed and cited by a code enforcement officer. The city.
Guys, please make sure you're muted.
Yeah, I'm hearing feedback. If the city is not able to prove its case, then I will dismiss the case and you may leave. These proceedings are being recorded. Therefore, all persons who are speaking should do so one at a time to ensure that all testimony is clearly audible on the recording device. If English is not your primary language, then please inform me when I call your case. We have a translator who will assist you during the proceeding. When your case is called, the property owner, agent for the property owner, and any witness that you may have, I guess you can click the raise hand button on your screen to let us know that you are here and we will acknowledge you. If you are not the property owner or an attorney representing the property owner, then you must present a notarized power of attorney affidavit in order for your testimony to be taken on behalf of your property owner. For new cases, you will be asked for the record if you are aware of and understand the violation that is being heard today. And do you understand what is required to resolve the violation? Please answer accordingly. City will present its case first, and then the property owner and or violator will be given an opportunity to testify on their own behalf, to bring forward witnesses to testify, to present evidence and photographs, and to cross-examine listed witnesses. Following the case presentation, I will issue a finding of fact on the case. If I find that a violation of city codes exists or existed at your property, then depending on the case type, I will set an abatement date for the violation to be resolved. Or for repeat violations, I will impose a daily fine amount. For new non-repeat cases, my order will include an abatement date by which you must resolve the violation, and a daily fine amount that I may impose at a future hearing date should the violation not be resolved by the abatement date. For appeals of civil citation, I will enter a ruling either affirming or reversing the citation. If the citation is affirmed, I will enter an order assessing a civil penalty, court costs, and a compliance date. If the violator does not comply by the compliance date, continuing fines and penalties will be assessed. If I find sufficient cause to postpone enforcement action at this time, I will table this case proceedings to another hearing date in the future. If you do not agree with my finding of fact and or ruling, then the property owner may appeal the administrative order on the case to the circuit court. An appeal must be filed within 30 days of the date of the execution, the administrative order to be appealed. In accordance with Florida statutes, if a person decides to appeal any decisions made by the special magistrate with respect to any matters considered at this proceedings, then the person will need a verbatim record of the proceeding. This record includes the testimony and evidence upon which the appeal is to be based. The cost of obtaining the verbatim record shall be the sole responsibility of the appellant, and it is recommended that persons who plan to appeal their case should provide their own court reporter at this proceedings. Pursuant to city codes, if the City of North Miami prevails in prosecuting a case before the special magistrate, the city shall be entitled to recover all costs incurred in prosecuting the case. The current cost assessment amount is $100 per case. Once the city records an order that imposes a fine and authorizes a lien against the property, then the city will charge additional administrative fees to record and release the lien. All right, Madam Clerk.
Morning, everyone. Thank you for participating in today's special magistrate hearing. I will review the process by which today's hearing will be conducted. Make sure your device is muted at all times unless you are giving testimony on a case. If you are using two devices to participate in today's hearing, be sure your audio is only enabled on one device. When your case is called, if you are signed into Zoom, you will receive notification giving you access to audio and video so that you may give your testimony. If you are here physically and wish to give testimony, you may sign in with the code clerk and await a text message indicating your case is ready to be heard. Upon receiving that message, you should immediately come to the code compliance office to be provided access to a computer. If you would like to speak on behalf of a case, once the case is called, you should click the raise hand button to be acknowledged. Before giving testimony on your case, please state your name, property address, and relationship to the property. If you wish to have an interpreter assist you during your case, please indicate that when your case is called. And that concludes all the instructions for today's hearing, Magistrate.
Magistrate, at this time, if we can just do the pledge and then do the oath.
Okay. Who will lead us in the Pledge of Allegiance?
We have one of our NMPD officers here. I'm going to just put the flag on the screen. And then if we can have all staff enable their video, please, to do the pledge. Please remember to enable your audio as well. Do we see the flag? Are we seeing the flag?
No, I
Yes.
don't.
Yes.
Okay. Thank you.
Okay. Are we all ready?
Yes, ma'am.
Okay. I pledge allegiance to the flag
Flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. If we can keep the city staff on to be sworn in. If you're going to be giving any testimony today on behalf of the city, please keep your camera and audio enabled to be sworn in.
Okay. Do you swear or affirm that the testimony you are about to give in these proceedings will be the truth, the whole truth, and nothing but the truth? If so, say aloud, I do.
I do.
Thank you.
Thank you. You all may disable your cameras and audio. If we can get the interpreters to enable audio and video to take the oath.
Do you solemnly swear or affirm that the translations which you are about to give in these proceedings will be accurate and correct to the best of your knowledge, skill, and ability? Say, I do.
I do.
Thank you.
If you can please announce for the record if there are any additions, deletions, or amendments to the agenda.
Magistrate, the amendments are as follows. Item number 6, 12297 Northwest 7th Ave LLC, case number CEGMP 2022-0091. This case has been postponed. Item number 19, 560 Northeast 124 LLC, case number CEMIS 2021-00042. This case has been complied. And item number 43, Partners of 822 LLC, case number CEZCU 2022-00433. This case has been complied. And that's all the amendments from today's agenda.
All right, please call your first case.
First case I will be calling is item number 1 through 5, which is 1180 Northeast LLC. Item number 1, case number is CEFAW 2022-000071. Item number 2, case number is CEGMP 2022-00114. Item number 3, case number CEMIS 2022-0087. Item number 4, CEODS 2022-00172. And item number 5 case number CEZPU 2022001117, and the officer is Jamal Murillo. And I believe we have Michael Etienne. You on behalf of that property as well?
All right.
We've given Mr. Etienne access, so we'll just wait on him to sign in. If just quickly, if you're here on behalf of the city or you're a panelist, it might be the NMPD officers that are signed in as January 26th hearing. Please take a moment and rename yourself so we know who you are, so that when your cases are called, we can quickly acknowledge you.
Good morning, Counselor.
Good morning, everyone. Michael Etienne of the Mike Law Firm. I'm here representing 1180 Northeast LLC. I was just retained to represent this particular individual, this particular company a few days ago. But I can tell you at this moment, I'm not prepared to mount a defense, as we haven't had an opportunity to forward over discovery or even conduct any investigative work. However, after discussing the violations that was raised by this code enforcement officer, it appears that our client will be complying, and he will. It seems to me all 5 of these particular violations are quite frankly, they're violations. They're reasonable violations. There's not really a defense that can be mounted here. So we just. His position is he's going to comply with all 5, but we just need some time. So I'm going to respect. Oh, one more thing. From what I understand, just so that I can profit for the record, Your Honor, it appears that he is in the process of evicting these tenants. This house needs a lot of work, and he intends to do so. However, he have not instituted the eviction proceedings. And now in Miami-Dade County, you need to give a tenant at least a 60-day notice to comply. With regards to one of the violations where it appears that the house needs to be converted back into a single family, I think like a drywall was put up separating the place. The individuals would have to literally be out of the house before that work can be done and complied. So I'm going to respectfully request that this item is tabled so that we can conduct our investigation and so that we can go ahead and get this particular client to comply. All 5 violations.
Okay. All right. Officer Murillo, anything you want to add?
No, Magistrate. Whatever you decide for this case.
Yeah. Magistrate,
Right.
if you'll be okay with tabling the item. We hadn't heard back from anyone on behalf of this case. They were opened back in June of last year. So this is the first time we're hearing from Mr. Etienne or the property owner in the matter. We're okay with the additional time. The city would just ask that when we come back, that there would be some significant, that they would keep us posted and abreast of whatever it is that's happening, to include the eviction process and, any progress that's made within the time that you prescribe.
Absolutely.
So let's reset for what 60 days work for you?
At least, just for Mr. Etienne, if you would at least indulge us in the 60 days, hopefully within that time frame, you guys have been able to expeditiously work on the initial steps to the eviction process, and then we can reconvene and kind of discuss, what the next steps should look like.
Absolutely, will do.
Sounds good. Thank you, Counselor. Have a good day.
Your Honor, I'm so sorry.
Okay, Michael.
Thank you.
No, go ahead. What happened?
He has another case.
Okay. Okay.
That is item number 42, which is Oxford Court Condo, case number MHVIO 2022-00176. This case was previously found guilty with an abatement date of August 5th, 2022. Fine was set at $500 plus $100 cost assessment. And the officer is John Lemestre.
Okay.
Now,
Do you have anybody else here on behalf of this property?
Yes, I believe Jerry Edward.
All right, Mr. Edward, I'm giving you access into the meeting.
Yes, hello. Good morning.
Good morning, sir.
Yes, I'm Jerry Edward. I'm here with my mother, Susie Edward. We are the property owner of the unit.
Thank you. And you are represented by counsel, right?
Correct.
Okay.
Jerry and Susie, can you guys please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? If so, please say I do.
I do.
All right. What's the update? What's going on with this case?
Okay, so I don't know about the guilt. There was a guilty verdict. We appealed it to the circuit court because we weren't able to be present at that hearing. We appealed it before Judge Daryl Trawick, and we eventually filed a motion to set aside we got an involuntary or a voluntary dismissal of that appeal when the city attorney agreed to put it back on the docket. So we did put it back on the docket, went back and forth with the family. So this is what happened. We were able to get some reports, forensic reporting of the roofing. It was our position that there's bylaw rules that must be complied pursuant to the Florida statute, and these particular homeowners did not comply with the bylaws to ascertain the source of the leak. So they did in fact get an assessment from a roofing company. I did read over the assessment. The assessment does not allege that our roof is a direct consequence of of water leaking into their unit. We still maintain that it's their AC. However, we did in fact get our own assessment done from Best Roofing. Unfortunately, we were unable to submit this into the evidence docket because the notice of this hearing was submitted to me via certified mail or to the building via certified mail on January 9th. I received it after January 9th, so I missed the January 9th deadline to submit our forensic reporting from Best Roofing. But just so that I can properly explain to the court and to these particular tenants what's going on, Best Roofing report, they installed our roof the roof back in 2014, and it was supposed to last 15 years. According to their report, our roof got a C rating, and I'm going to email this to both the code enforcement officer and to Mrs. Patterson. We got a C rating. The roof is supposed to last 5 to 7 more years. And at the moment to change the roof, we need $350,000. But in the report, and I'm just going to be candid here, they did find deficiencies in the roof. They found 2 or 3 punctured entry points. 26 of our pitch pan needs to be resealed. So there are some deficiencies in the roof, and that's in the report. And so far, we've already executed the agreement where we're supposed to pay $5,204 to conduct the repairs that Best Roofing recommended. So this was executed after support of the majority of the board on January 25th. So again, we didn't have time to submit this evidence because we received the notice of this hearing after the January 9th deadline, but work is being done pursuant to the report that we got from Best Roofing regarding our roof. So what I would request is that we let Best Roofing, we already we've already agreed to allow them to do the work. I'm going to recommend that they get the work done and see what happens. My assumption is even after the work is done, I think that they're going to still suffer from leaks because it's our position that the leaks are coming from the pancake unit in their ceiling from their particular AC unit. And last but not least, on their report, not only do their report does not specifically state that there's a leak in their area, because again, it's a 39 unit building and they're the only ones who allege that their unit is leaking from the roof. But nevertheless, our position is that it's coming from the AC, but they did submit some photos of water seeping into the attic. But those photos are of the east side of the building. They live on the west side of the building. Nevertheless, Best Roofing has been retained to conduct some maintenance work. We're paying the money, and and they might need some time, but I think after they conduct this work, they're going to still find that their roof is leaking, but we'll see. And that's our position.
All right. So I will not ratify the fine for now. I will let's reset. I'm sorry, Mr. Edward, is there anything that you want to add, sir?
Yes, for sure. Thank you. So just to give you a brief summary, we've been going through this since August, way before August, but January. And honestly, we have multiple companies that came out besides Big G Roofing Company. So we actually had a restoration company come by and check our ceilings. And we also had plumbers, because the previous time we had this meeting, Michael Etienne claimed that it was a cast iron pipe before. So that's why the case was put to the side. And we did our investigation. We got a few licensed company to come out and check out the situation. And they cut open the ceiling from the ceiling area to the AC area. We cut it open. Once you cut the ceiling open, there's nothing in between there's just the ceiling and the roof up top. So they took photos. We have photos of the damage of the roof within the ceiling. And also we have reports of how many water that was clustered inside of the roof, between the roof and the ceiling. So it caused it a lot of damage. At the moment, we do have kids, and like I said, my mom, she's in that room area. It's not towards the AC, but it's actually inside the room and the whole room area. So we do have photos, and there's mold been growing out of the unit room, and it's just very bad. It's getting worse and worse every time it rains. So yeah, this is the situation that we have to deal with day in and day out.
Officer Lamesh Troy.
Yes, ma'am. Mr. Edward, he provided documentation from Big G Roofing, and I have the quote from that report stating that the roof is holding over 3 inches of water and could be getting water through the seams of the TPO system and also through the pitch pan. Walking on the side of the roof, it feels like there has been water infiltration that has penetrated the TPO system. We recommend to install a taper system on the roof in order to create a positive slope so the roof can drain properly. That's from the Big G Roofing Company, and also the company Restoration One of Boca Raton. Mr. Edward and his family have paid over $9,000 to mitigate the water from the ceiling. And he provided photos as well of the ceiling where there is no cast iron pipes. It's just the ceiling to the roof. This
is an ongoing issue, is what I'm trying.
Yes, ma'am. It's
based
ongoing.
on what you're saying.
It's
and
ongoing.
You're saying there's possible mold.
Correct.
It's typically when there's water, resting in one place, that can cause mold. Now, Mr. Etienne, have you had an opportunity to review what Mr. Edward has submitted with your roofing company?
No, Your Honor. I did get a copy of of their best roof. I'm sorry, the Big Roofing, but I didn't get any copy regarding the restoration of the restoration or paying $9,000. We didn't get any. This is the first we're hearing of it. And second, let me just make this clear, Your Honor. The problem was, the holdup was this family. The way the bylaws are written, whenever, and this is in our bylaws, and we addressed this before, whenever there's a leak in a unit, the unit owners are responsible for it. The homeowners association is only responsible for the roof and the plumbing underneath the building. So there's a procedure in place, and the procedure is what they finally complied with. The last time we were at the hearing, I made it abundantly clear that they're supposed to get experts, open up their walls. That was required pursuant to our bylaws and our condo regulations. And they finally did that. So this is what they're supposed to do. Now that they've done that, we hired the individuals who installed the roof. And I made it clear to them, the only thing the city of North Miami can do is find the building. The city of North Miami can't force us to fix anything. They can just find the building, and they can find the building up to $5,000 every month or every day, but that's to not their owners. They're not tenants of the building. So if the building gets fined, they are at a disadvantage. So just to be clear, they've complied with the procedures now. What they've done now was what was supposed to be done a year ago or last month or last year when they alleged that they had a water issue. So now they have complied with our bylaws. We in turn have already paid a company to at least remedy the situation as they saw fit. Now, if they want to ask the city of North Miami to find a building, of course, we don't think that they have grounds to do that. But at the moment, if they want to ask that, that is not to their advantage. But from our position, we've complied with what we have. We've done what we're supposed to do. And at this moment, they have done what they were supposed to do, but they've done that now. But no, I have not seen a report of the mediation restoration.
Okay. Mr. Lemestre, what do you suggest if we give the parties, 30 days to exchange documentations and, trying to see if there's an agreement that can be done in terms of how we're moving forward? Doesn't appear that. Go ahead.
No, I just wanted to say that, to Mr. Etienne, when is the roofing company going to come out and remediate the situation?
Well, the contract was executed on, I don't know if you can see this on the screen, but it was executed on
yesterday,
January 25th, 2023. We got the report. We got 2 reports, in fact. But let me be clear, Jonathan. The only thing we can do is go by what our experts are saying, the individuals who have installed the roof. So they're going to come out and they're going to do what they see are deficiencies. If the leak stops, it stops. If it doesn't, it doesn't. The fact is, the building was built in 1972. I'm not the president of the association anymore. I'm just the attorney who works there, who works for the building. The bottom line is the roof's going to eventually have to change. Now, if that particular unit is at a position where let's say we're going to pay for this and they're going to come out and do what they're supposed to do. We've already paid. We're paying the $5,000. If it doesn't stop, then the city has the right to condemn that portion of the building and say, look, we're not going to allow anyone to be in that portion until the roof is done. But then we got to pay $350,000 to change a brand new roof. So they're going to, and if the building's condemned, and they can't have access to their unit 304, then they all just have to leave. And that's what's going on throughout the entire South Florida region. So hopefully this works. I say give them 30 to 45 days to get this done. And if this isn't done and they're still leaking, just condemn it. Condemn that portion until the association have the funds to change that portion of the roof. But our position, we've done everything we can do to stop this bleeding. But again, it is an old roof. It was installed in 2014. It's supposed to have 5 to 7 more years. We need $350,000 to change the roof. So we got to come up with that money in 7 years. But at the moment, we've done what we can do to help stop the bleeding. So I say give them 30 to 45 days to come out there. And if it doesn't stop, just condemn that portion that wherever it's leaking, just condemn it until we can come up with the money. That's the only thing I can recommend in good faith. Better than. But last thing, I'm so sorry, Magistrate, Your Honor, but last thing, it is to everyone's advantage. Before fining the building $5,000 every day for not having the money to be able to change a roof for $350K, our position is we would prefer to basically condemn the portions where that's uninhabitable so that we can stop the bleeding. And then we'll come up with the money with special assessment, which is going to take a year or 2 to fix it. But we prefer that over finding the building $5,000 every single day because we don't have any money to change the roof. And I stop there.
Madam Magistrate. Oh, well, I don't know if Mr. Edward wants to chime in, but I'm okay with giving him 30 more days. He did provide documentation to remediate the situation. I could give him 30 more days, but I don't know if Mr. Edward would like to chime in.
Right. I just wanted to ask Mr. Etienne. So, because I noticed he pinpointed a lot about, if the roof is fixed, if it's still leaking, the city will have to, make that pay that fund. But what happened if it does stop leaking? What are your actions, Michael Etienne? What would be going on? And what are the bylaws, basically, for this action?
Do I have permission to respond, Your Honor?
Sure.
Okay, so the way it works, so the bylaws were clear that what you've recently done in getting this report, open up your walls to ascertain or to determine the leak, the roof leak, then at that moment, the city can't do anything. The city can only find the building. So what happens thereafter, if it does stop, then you are required to fix whatever it is within your unit. The state statutes are clear about that, and the bylaws are clear about that. We're just responsible for the roof, and the association is just responsible for the roof and the sewer lines underneath the building. And as you can tell, with regards to unit one of the units that tried to sue the association, we ended up getting a lot of attorney fees that they can't pay for. So anyway, to answer your question, you're responsible for whatever damages that happen within your unit, but you finally complied with what the bylaws are said that you're supposed to do, which is open up the walls. And again, if it's uninhabitable, Edward, then that portion of the building would have to be abandoned, and the city, it would be up to the county and the city to decide that. If it doesn't stop leaking, unfortunately, that portion just might have to be abandoned.
Let me just for clarification purposes, you're indicating that if the damages to their unit is caused by the leaking roof, that typically is that the condo association is responsible to fix. You're saying that they solely are responsible for that damage?
Yes, Your Honor.
That's how your bylaws read, that the unit owners are responsible for the damages within their unit, even though the repairs were supposed to have been made by the condo association?
Yes, Your Honor. That's why our condo is very desirable. So we had a trial on this before. So the way it works, they're supposed to follow the prescription in our bylaws to alert us as to where the leak is coming from. Once they do that, then we have a time frame to do what we can to remedy the situation. One, they are at fault because they took too long to follow the bylaws. They finally did after our last hearing. They decided to follow the bylaws. Now, at this moment, we have a period where we take a step to see if we can rectify the situation. But damages that are caused, even if because again, Your Honor, the association isn't an individual's association. It's for the entire building. So when they drafted the association, when they drafted the bylaws, initially the developers did so for the benefit of the building as a whole. So if the roof is leaking and it leaks into a unit owner, it's not an apartment complex. That unit owner is responsible for the building like all the other 38 unit owners. So that's why it's drafted like that. And we actually won a case law on that last year before a judge. I forget the judge's name, but we actually won a case law, and he knew about it because it was a big thing. And so anyway, and of course I had to waive attorney fees because that unit owner couldn't afford the attorney fees. So I just had to leave that alone. But yes, Your Honor, that's the way it's written in our bylaws. And that's what the precedent been thus far.
All right. So, Mr. Edward, I suggest that you review the bylaws and act accordingly. At this point, let's table this for 30 days, and you guys do exchange discovery documentations and see where we go from there. We'll see you guys in another. Go ahead, sir.
I'm so sorry, Your Honor. I'm not going to be in town in 30 days, but what I am going to do, I'm going to forward over all the evidence to Ms. Patterson. I'm going to forward everything we have to Ms. Patterson. The second we know exactly when these people are going to come and fix the roof, we'll do that. And I would recommend once I send over the documents and they come and fix the roof, if code enforcement want to go back and conduct other inspection, they can. And if other hearing is necessary thereafter, because I won't be in town, I'm going to be out of the country in 30 days.
Magistrate, if I may, I just want to clarify, our next hearing is not actually until March 2nd. Mr. Etienne, so just for clarification, are you stating that in between now and then, the repairs are slated to be made? Is that what's anticipated?
Well, yeah, according to what the best roofing analysis and forensic evidence shows, everything they recommended on the report that I'm going to forward over to you, it's going to be paid for and done. Now, those repairs will be made. Will it stop the leak or not? I don't know.
Okay, so, and what do they have an anticipated completion date? Because I suspect at this point you guys haven't applied for permits or anything yet.
Well,
So likely that won't be done in the 30-day window because permits and all of that have not yet been applied for.
Okay, if you want us to reset, let's reset till March. You want to
Yeah,
do
I
that?
just wanted to.
'Cause that would give them plenty of time.
Yeah, I just wanted to just make sure that we were clear on what what to expect, in the March hearing, or, what to expect between now and then. But yeah, I just wanted to make sure that we kind of iron out those particulars. Mr. Etienne, feel free to send over whatever you have. Just, if we'll reset for March 2nd and, just hopefully that there's some either applications already submitted into the department for next steps as it relates to the remediation.
Will do, Ms. Patterson. Thank you.
All right.
Thank you.
Thank you, guys. All right. Thank you, Mr. Edward. Good luck to you, sir.
Thank you.
I'm going to proceed with item number 20 and 21. It's 999 Northeast 125th Street, Inc. And case number CEFOB 2022-00370. And item number 21, case number is CEZCU 2022-00282. And the officer is Shannon Sanders.
I have attorney Frank Wolin here on behalf of this property. It looks like he'll probably be joining us here in a second.
Good morning.
Good morning, sir.
Hi,
How are
Mr.
you?
Wolin.
Fine, thank you.
Officer Sanders.
Shanna Sanders, City of North Miami, co-compliance officer with City of North Miami. For these cases, I did speak to Mr. Wolin yesterday as well as this morning. I'm going to ask that these cases be tabled. He brought to my attention he recently obtained the required permits that were needed in order for him to submit the applications for the certificate of use. He did ask for a 30-day extension, but, as I explained to him, and he'll probably, say as well, 30 minutes before the hearing is not the time to ask for an extension or, 12 hours before. So I am okay with giving the property owner as well as Mr. Wolin an extension. He has come to the city and submitted the application for the certificate of use as well as the business tax receipt. His client came this morning to submit the application. So if we can, I would like to have these two cases tabled for 30 days, if not even 60. I'll even give them that much, 60, because I know their office is moving a little slow, being the community planning and development office is moving a little slow with the applications. So again, we can extend these cases for 60 days if possible.
Thank you very much, Your Honor. I don't think I need to say much. Officer Sanders has really said it all, and our clients have spent a lot of money and made a great effort to come into compliance. It's taken a long time, but we're near the finish line. Thank you, Judge.
All right. Okay, so are we resetting it for 60 days or are we setting it for March, Crystal?
I would say let's do March and just get a status update. I would like to just kind of stay abreast of it. Or Mr. Wolin, if you have something prior to then, let us know, if there's some changes made. For clarification, Shannon, you said that the applications have already been submitted?
Yeah, he submitted them yes, I'll say yes. He submitted them this morning.
All right. Okay. So with that said, then yeah, we can do 60 since the applications have already been made and it's now it rests on the city.
Thank you so much.
And if you come in, if the licenses, are issued prior to then, just let us know so we can go ahead and close out the cases for compliance.
Thank you so much.
All right. Thank you, sir. Reset 60 days. Good luck to you.
Thank you.
We have item number 24 and 25, which is Cesar D. Garcia, case number CSTA 2022-00054, and item number 25, CESTR 2022-0034. And we have the North Miami police officers here on behalf of this case.
Can you guys hit the raise hand feature if you're here for this case? I'm not sure who, if you're an MPD, please enable your camera. You guys, NMPD, if you're here on behalf of the short-term rental case, I don't, okay. Is it, and then is a property owner here?
It's supposed to be Officer Bryant Monte.
Okay. They didn't rename themselves, so they would just need to enable their cameras, because I don't know who is who. And then is the property owner here, Jose Peggy? You know? The property owner is not here.
No.
Okay.
Okay,
All right. Would you like to proceed?
absolutely, because the officer has other things to do. So let's hear the case.
Okay. Officer Perez of the City of North Miami said we're hearing the case in regards to the property at 1987 Northeast 123rd Street. If you'd like, we could hear both these cases at the same time, considering they're within the same violation. The first case is CESTA 2022-00054. This violation is a repeat offender violation. They were previously cited and have pretty much continued advertising for short-term rentals. The property was previously cited in 2021, and they were found guilty. At this point in time, the violation still exists. The advertisements remain up, and they're showing clear disregard for city's ordinance and city's efforts to try to reduce short-term rental advertisements. So at this point in time, the city's seeking a monetary fine as well as an adjudication for this as a repeat offender. For the second case, that being the actual rental itself, there was a rental that occurred, and I'll let the officers speak to what they observed. But in essence, a rental did occur on the actual rental site itself. They were responded to on April 21st at 2 a.m, so pretty much pretty late as a disturbance, but pretty much the lack of thereof of respect to the code is causing a disturbance not only to the surrounding properties but the neighbors and the community itself. So we seek that as well as an adjudication, but a fine is set for this violation as well. And then I'll let the officer speak in regards to what he observed on April 21st.
Officer, please state your full name for the record, sir. Can you hear us? I'm not sure if he can hear us. What is the officer's name?
Can you hear? Can you hear?
Officer Perez, what is the officer's name? And I'm not sure he can hear us.
Officer Carminati, can you hear me?
Yes, now we can. Thank you.
Okay, thank you.
I'm sorry, Magistrate, I actually have someone raising their hand. I don't know if they're raising their hand on behalf of this item. Do you mind if I ask him if he's here for this case?
Sure, go ahead.
Alfred Bryant, are you here on behalf of this property?
Can you hear me?
Yes, I can. Are you here on behalf of this case?
Yes, I am. This is Officer Bryant, Alfred Bryant.
Okay, so let me give you access to the meeting. So Calamonte, I'm sorry, I may be mispronouncing your name. Are you here for this property?
Yes, I am.
Okay.
All right. Were the two officers sworn in?
I'm not sure.
I was sworn in.
Okay. Officer Bryant, can you, do you have access to Zoom? We can't see you.
I just gave him access. He should be joining.
Okay. Thank you, sir. Were you sworn in?
Yes, I was.
Okay. All right. Okay. Who wants to go first?
Okay. I'm the primary officer that responded to the address of 1987 Northeast 123 Street. It was an anonymous complaint for extremely loud music and yelling coming from the residents. Officer Carminati was my backup officer who also responded. When I arrived, I met with the occupant. She identified herself as a short-term renter. She said she was renting the residence for about 4 days. And she further advised that she rented through the app or the website booking.com. And the total amount that she paid for the rental came up to $1,895. I told her why we responded because of the complaint of the loud talking, and she told me that she would keep the guests quiet to prevent any further disturbances that night. And we didn't respond again after that incident.
Okay. Thank you, officer. Is there anything you wanted to add, officer?
I have nothing to add, Magistrate.
Okay. All right. And what are you seeking, Officer Perez?
An adjudication as well as a one-time fine for the rental itself, and then an adjudication as well as a repeat offender fine for the advertisements.
All right. Based on and what did you say about notice for today's hearing?
Oh, my apologies. I completely forgot to mention that. So the property was sent via certified mail on January 9, 2023. And it was also posted at the property on January 9, 2023. So they were properly noticed for this hearing. The original violation was sent via certified mail back in August 5th of 2022 for both cases.
Special Magistrate, I just really briefly wanted Jose to brief you on what the prior fines were set at, just for your information, as these cases are being brought as repeat offenders. Do you have that information, Jose? Or clerk, can you tell her what the fines were the last time for each item?
So for the repeat offender for the advertisement, they were previously found guilty on October 1st, 2021, and they had a daily fine of $500 that's still ongoing. It's a fining case. It's ongoing right now. That's for a different advertisement they still have active. And then they had a one-time fine for the actual rental itself that occurred previously. They were found guilty in October 2021 and was fined for $1,000 for that.
Okay, so the $500 for the advertising, you said it's ongoing because the advertisement is still up?
Correct, for a separate, different advertisement than the one we're bringing today.
It's different? How is it different?
It's a different website.
I see. Okay. All right. So based on the unrebutted testimony of the code enforcement officer and the two officers who are present and testifying today, I find that the violation still exists. I also find good notice, given proper notice, the owners have failed to appear, hereby find in favor of the city entering adjudication. I do find that this is a repeat violation. There would be a one-time fine amount of $1,000. And property owners have 30 days by which to, I guess, put down the advertisement. If not, there will be a daily fine amount of $500 until such time that the advertisement is taken off the websites. Thank you, officers. Please stay safe.
Thank you.
Thank you for being here this morning.
Magistrate, is that your ruling for both items? There's two cases. One referenced the ad, and then the other one is referenced the actual rental activity that was that the officers testified on behalf of. So you have two separate items before you.
Correct. For the I give a one-time fine of $1,000, and for the advertisement is 30 days followed by $500.
Okay. And that's your ruling also for number 25 as well.
Number 20. What part of number 25 did I miss?
So 24 is the ad, and then 25 is the short-term rental activity. So two separate provisions.
Correct. For the short-term rental, I give a one-time fine of $1,000.
Okay.
For the advertisement, it's 30 days to take it down. If it's not taken down within the 30 days, there will be a daily fine amount of $500.
Got it. Okay. Clerk, did you get that?
Yes, I did.
Okay.
Thank you.
Thank you. Thank you, guys.
Thank you.
I'm going to proceed with item number.
Clerk, can you enable your video, please?
I'm going to proceed with item number 16 and 17, which is 1330 Apartments LLC, case number CEMHS 2022-00391. And item number 17, case number is CEMHS SCN 2022-0015, and the officer is Shannon Sanders.
I have Andrea Andrada here on behalf of this property.
Good morning, ma'am. Please state your full name in relationship to the property.
Good morning, everybody. Good morning, Honor. My name is Andrea Andrada, and I'm managing this property since my client's purchase about 2017.
Thank you.
Shanna Sanders, City of North Miami Code Compliance Officer. This is a case for a property address 1330 Northeast 127th Street. I start with case CEMHS 2022-00391, referencing the stairways, railings, sidewalks that needed to be repaired upon doing an inspection during the annual housing inspection on April 28th of 2022. I observed stairways, railings that were rusted. They were shaky, not well balanced. I sent out a notice of violation to the property owner, as well as the registered agent, notifying them of the violations that were observed. I did not have any contact with anyone until posting a notice to appear. Upon posting a notice to appear, I did see some activity of some work that had been done. Upon my last reinspection, still more work that was being done. Repairs were being made. As of the 12th of January, violation still remains. I'll let Ms. Andrea explain what's going on at the property and give testimony as to why it has taken so long and or when the final repairs will be done.
Ma'am?
Yes. Okay. We sent the pictures on January 19 about the repair that was done, and everything is taken care. Other than that, we are in the process of getting the 40 years inspection. So that is why we are taking so long, because we are getting different quotes. Unfortunately, the first engineer that we hired, he took vacation during 2 months already. He disappeared technically. So we hire another engineer now, and he's taking care. But the repairs that was done, I sent picture to the inspector, and she also tell me that we have to attend in also the magistrate today.
What repairs do you have that was done?
It was all the screening on the windows. Let me see.
That's the other case, right, Officer Sanders?
That's correct. The pictures that she provided to me were pictures of the railings being repaired, the sidewalks, they filled in the cracks, and everything was in compliance. As I explained to her, we do a final inspection that we have scheduled on the 12th. She sent it to me, I believe, as she already stated, on the 19th or 20th, which was well after the reinspection date. So just as I did with Mr. Wolin, I, explained to her, you have to come in, give testimony, upload pictures to show what compliance looks like as of her last photos and what she's stating. I didn't see anything uploaded, but, she's here giving testimony stating that it's been complied. I myself have not done any re-inspections since the 12th.
Yeah, okay. We sent the pictures to the inspector directly. We don't upload it to the link. Yesterday I didn't, but we sent to the inspector as soon as we have it. It is a big report that it took 18 pages that we are getting different quote for that. So it probably takes 30 days or 60 days if you can give us that extension.
All right, so repairs are done on pending inspection. That's my understanding, correct?
Do they have permits?
No, they don't have permits for it, but the cracks were minor. It was, minor facial things. If it was, a larger percentage of the building that needed to be repaired, or needed, some things done.
It was minor on the stairs. The issue on the stairwell was the railings and all of that was minor. I know the building official is here. I just want to ensure and confirm that the repairs, based on the photos that we demonstrated, magistrate, there was no need for any permits. Obviously we're concerned with the buildings and we want to ensure that the work was done up to building standard.
Chair?
Yes. Hi, good morning, everyone. Good morning, Special Magistrate. Good morning, Ms. Patterson. Let me review the photos again. So the thing so far, the railings, because there's some heavy corrosion on that. And some corrosion.
So, and then it looks like, Mark, that these are like what the repairs look. I don't have any repairs on the stair pictures. This looks like in the sidewalk. They just fixed cracks in the sidewalk, which I suspect that's fine. I mean, you could probably say better than I can, but my concern more so is the stairs.
Yeah, the railings. I think that's a concern. We probably would need some type of letter from the structural engineer saying that it's stable, but eventually you're going to have to do something with that.
So Andrea, the information that you're saying you sent over to me, I'll email you, or you can text me, separate from this hearing, and provide that to the building official, showing that 18-page documents that you could not upload, giving that information that he's asking for.
Yeah, not a problem. We will. That's why I explained. We hired one engineer that disappeared, so now we have another engineer that is working on it. Not only on the paint of the floor and the railings, is the whole thing. What we focused, it was on the windows that you requested in the other case, and the screening. We changed all the screening of the building, so that part is everything done.
Yeah, we'll move on to that case, in a minute. We just want to make sure we're addressing these issues. That's why, again, I was asking you to upload the pictures, because I thought that this may come up in conversation, but, as it was not done. I'm okay with tabling this case, Magistrate, to give the building official time.
Yeah, I wouldn't recommend a table. Magistrate, I think the city would ask, this is the first time the cases are being brought to before you, so we would request we would ask for an adjudication, and then you set a compliance date. And during that time, she can forward whatever documents she has for review, and if an inspection or permits or whatever it is are needed, we can let her know during that time what needs to happen. But the city would ask that the magistrate would rule that a violation did exist.
Okay. I'm also concerned with the building official, Mr. Mori, has asked that your engineer can provide a letter to the city indicating whether or not it's what was it that you asked for?
Structurally sound.
Yeah, it's just that is stable.
I understand.
Stable for the time being. Let me ask you, Miss Andrea. The 18-page report is an evaluation that was done.
Yeah, correct. Because we have to submit the 4 years inspection, so we are in that process. That's why you cannot just repair one thing, because it's the whole thing. The roof was checked, the cracks was checked, everything was checked before you coming in, because we are in the process of 4 years inspection. Okay. So that's why we focus on the things that we can do without any permit, which is the screening and things like that, but not the biggest thing, because we have to wait for them. We have to wait for the quotes and repair it and pull the permits and do everything.
So, Special Magistrate, I could review that document, and I'm going to need to visit the site. Then from that, issue a letter of additional actions they need to provide. If that letter, that the 18-page letter is deficient in some information, I would ask for additional information since they're under the 40-year. So there's some additional things they may need to do in conjunction with that 18-page letter, 18-page report that I have to review. So I guess we can move for the, what Ms. Patterson said, and I'll follow up on the back end with the reports.
All right. Based on the evidence presented, I find that the violation does exist. Find in favor of the city intern adjudication. I'm giving, what is the abatement date? I don't have that.
Clerk?
January 19, I believe. No, 12.
Do you want this to come?
Not you, Ms. Andrade. Go ahead.
Magistrate, do you want this to come before you or the other magistrate?
That's fine. I think that in the meantime, once they can provide Mr. Jean the information, I think we should be fine. And he can expedite whatever needs to be expedited during that time. But you can give me the an abatement date and a hearing date.
The abatement date for your next hearing is March 16th, and then the hearing date is April 6th.
Be informed.
Is that okay with your Officer Jean?
Yes. Yes.
All right. So again, I intern adjudication, ma'am, that gives you plenty of time because this your abatement date is March 16th. Please reach out to the code enforcement officers and building official and provide Officer Jean with the documentation, with the letter that he's requesting from your engineer, and trying to work with them as best you can to try to get what needs to be resolved, at least on a temporary basis, get that resolved. And then we will see you back here in April. And the daily fine amount is $500.
For each?
Is March or April? I'm sorry.
March 16th.
Your abatement date, the abatement date is March 16th. The hearing date is April 6th.
I have it. I have a question.
Yes.
Who may I contact for 2 cases of co-enforcement special magistrate? Because I tried to contact everybody, and I had no answer. I need to speak with someone about the 2 other cases that we have in the same unit that it was imposed a lien. And also, I was submitting the application for certificate of use and tax receipt on September last year. And when I went to the office, they just processing June 22 in November. So I spoke with the inspector. I spoke with co-enforcement. I spoke with the people at the Office of Certificate of Use. And after 20 minutes that I prayed to her, she helped me out. She sent an email to everybody, co-enforcement, to everybody to try to help me out because we had this situation that there is a delay between department and I don't have anything else, but I still have the problem. I don't have the certificate of use. I don't have the application of, the tax receipt already in this property, but I don't know who has to talk, It's unbelievable. It is no communication.
Ms. Andrade, you can follow up with the building official, the same person that's here today that's going to review your 18-page report. The inspection process falls under his office, and so you can speak with him when you guys communicate about the issue today, okay?
Okay. Sounds good. Thank you so much.
There was another item, Magistrate, on the same property, referenced the screens in the windows. I don't believe that one was heard. I believe he indicated that there's compliance. I intern adjudication involved and pending
final inspection.
Thank you.
So we'll allowing the two cases to run together.
Okay, thank you. Thank you, Ms. Andrada.
Thank you. Thank you, everybody.
Bye-bye.
Thank you. Good luck to you.
We have two other police officers here. For Mauricio D. Duhauer, case number CSTR 20220035, and the officer is Shannon Sanders, and that's item number 33.
Do I have anyone here on behalf of this property?
No, not anyone physically, but we do have the North Miami police officer here.
Good morning, Officer Revere.
Good morning.
Were you sworn in, sir?
Yes.
All right, thanks. Shanna, are you there?
Yes, I am. I was trying to pull up my cases. Shannon Sanders, City of North Miami Co-Compliance Officer. This is a case for a short-term rental at 12746 Northeast 4th Avenue. I received an email regarding a violation referencing a short-term rental that transpired at this property. Upon receiving that email, I'm sorry?
Complaint?
Receiving that, the email, violation was opened, mailed to the property owner, certified mailing, did notice to appear mailings. I have not had any contact with anybody at all from this property. I am presenting this case as a repeat violator, seeing that they have already been presented to the magistrate on May 22nd of 2021, whereas they was adjudicated and had a fine. I am showing the police report on the on the screen, incident report showing that the police went out for loud music at the time of, speaking about the music, from what I read in the report, the occupants at that time verbally spoke on only being there for the weekend and renting it as an Airbnb. I'll let the officer who's present give testimony on that, since, it was the report that he provided. But again, as of my inspections, my postings, I have not had any conversations with anybody regarding this matter. So again, I'll let the officer speak on what transpired that day that he was at the property.
Magistrate, I just want to clarify the email complaint thing. We received a complaint from the police department referenced this incident report to follow up regarding the short-term rental. So we're presenting the case, and we have the officer to give testimony on the call that he when he went out referenced loud music.
Sure. Officer Sanders, you said this was adjudicated prior, you said back in May 2022 or May 2021?
Not this case, but they have another. I'm presenting.
No, I understand. I'm saying you said that there was an adjudication prior. You said it's a repeat violation. You said the prior one was that May 2022 or May 2021?
I'm sorry, I'm looking at my file. I'm showing it as September 22nd, 2021.
Okay.
What was the fine?
$5,000, a flat one-time fee of $5,000.
Got it. Okay. All right, officer. Good morning.
Yes, good morning. So on March 16, 2022, I responded to the address, the QTH of 12746 Northeast 4th Avenue, reference to loud music. Upon arrival, I was able to hear loud music and loud talking from the swale. So directly in front of the property, I was already able to hear the loud music. I was able to make contact with someone that was in front of the residence, a Caleb Toller, who advised that they were renting the property through Airbnb for a short-term period. He advised that the actual renter, the person that rented the property, was not present, and he didn't have any more details as far as the means as to application or which way they are able to rent for the property. They did advise that they were leaving that same day at 10 in the morning. They were at that time advised of the complaint of the noise, and they did turn off the music and stop the loud talking.
All right. Thank you, officer.
We also have Officer Castro here on behalf of this case as well.
Were you the main Ravila or?
Yes, I was the primary officer, and Officer Castro was my backup officer.
Okay. Thank you. All right. Based on the unrebutted testimony of the court enforcement officer and Officer Ravila, I find that the violation did exist. Also find in favor of the city. Now, let me ask you, this one is basically for the short-term rentals. We're not talking about, I didn't hear any testimony regarding the advertisement. Is that correct, Officer Sanders?
That's correct. This is only for the rental. I tried to look online to see anything going for advertisement, but I wasn't able to locate anything.
Okay. All right. Based on the evidence presented, I find that the violation did exist. Find in favor of the city. Also find good notice, given proper notice. Owners have failed to appear. Hereby enter an adjudication and a one-time fine of $1,500.
Magistrate, you're saying 1,500, magistrate?
Yes.
You know, I just want to make sure that we have on record. I mean, I think you already know, but this is a repeat violator. You know, the first one was for, 5,000. So, if we can, I'll be bold enough to ask, can we match that at least? Seems like the
only
first
reason, fairness, due to all fairness, the only reason is because the last one that I did, 1,000. And so it would be a major leap for me to, change course here. And I'm talking about the case, not Officer Ravila's case. I'm talking about the case that I adjudicated prior. You understand? And so that's the reason why. But now, if it were to come back to me, now we have two, right? We would have two prior cases, and therefore that would definitely necessitate some type of punishment. And so just remind me, if this address were to ever come up again, just remind me that they have been fined at least twice. Okay?
Okay.
All right. Thank you. Thank you, officers. Please stay safe. Thank you for being here this morning.
Thank you, Magistrate. Good morning.
Bye.
Then proceed with item number 18. Item number 22, which is Benjamin R. Jacoby and wife. Case number is BUNSF 2022-0001. This case was previously found guilty with an abatement date of July 8, 2022. Fine was set at $500 plus $100 cost assessment. The magistrate further ordered the structural report to be submitted to the building department within 15 days, which was June 6th of 2022. And the officer for this case is Vanessa Willis.
All right. Good morning, Mr. Jacoby.
Good morning, Magistrate. How are you?
Very well. Good seeing you.
Right. So should I bring us up to date from my end, or we'll let the officer tell his story first?
I'm sitting in for good morning. I'm sitting in for Vanessa Willis.
Okay.
In terms of the case.
So our permit was issued. And we had an inspection. We didn't pass the inspection yet because we don't have our engineering report that's required. But the work has been done, and I'm saying it's done correctly, but the engineer has to do that, and I would probably need 30 days now to get that report for the city.
Okay. Officer Jean?
All right. Good morning again. Mr. Jacoby, I actually examined the file this morning, and I wasn't aware that the file was issued because last special magistrate meeting,
we didn't have a permit.
I made it clear that the engineer Edward Landry.
We have a new engineer. We've already paid them. We're just waiting for the report.
You're muted.
All right. Basically what I'm going to do, I'm going to take back the permit and have you resubmit the correct information for repairs with the new engineer. So that way we can reissue it correctly.
Okay, so that report that I'm getting, I don't know when, but let's say the next 10 days or 2 weeks, I'm going to have to resubmit it with the permit application?
No, well, yeah, with the corrected permit application. But also, I want you to be clear, the new engineer should provide repair recommendations. Actually, I put something in the file that says owner/contractor submit signed, sealed, and dated documents addressing repair recommendations, immediate shoring placement, immediate precautionary measures, per my certified letter, January 28, 2022. Also, to make sure that you correct the work description to read repair and evaluation of soffit over public sidewalk and covered driveway. And I'll try my best to see you.
I'm writing it down. I'm a slow writer.
Okay, no problem.
Repair and evaluate.
Yeah, a repair and evaluation of soffit over public sidewalk and covered driveway.
Got it.
Okay,
super. So, just so the magistrate knows, we did get an engineering report, but the city is not going to accept that, and that's why we had to get a new engineer to do it, and we understand the reasoning behind it also. So, but just to let her know, that's one of the delays that we had.
Okay.
Yeah, and also, Special Magistrate, I want to express, this has been going on since, I guess, a little short of a year. So we want to make sure that, and we express that, it's, urgent matter, because it is a safety concern that, we really can't wait any longer, but, to move forward, Special Magistrate, however you see fit, so that way we can hopefully close this case.
Okay, so are you asking for a shorter reset? Because I've been resetting things to March, well, really April. Are you asking for a shorter reset?
Can we move to some, I guess, any fines or as I'm not sure if fines have been assessed, but any fines so that way we can ensure a speedy compliance.
This case was previously adjudicated. Okay. It's already been adjudicated. I haven't ratified the fine. It was adjudicated.
Okay.
When was it adjudicated? Right on. So what is it that the
I guess a shorter.
Do you want me to reset it within 30 days to see where we are and what's going on, or?
Yes,
okay.
30 days. Yeah, because really, if we don't get it resolved, it's my only resort is to carry this to unsafe.
Okay. All right. So let's reset 30 days, Madam Clerk, because the building official wants to make sure that
when they first started this, immediately they roped it off and put barricades, and then we immediately did remedial work, and they came back out and removed that. So I know that they're concerned about a safety issue, but it's been fixed. But I understand, and 30 days will be fine. I just don't want the city to think that we're not acting responsibly and responding properly to this.
I mean, then just give the building official what they need just to make sure that at least it's safe.
That engineering report, when they get it, that should resolve that issue for them.
Correct. Okay. All right. Okay. What's the date? Madam Clerk?
Next case is item number 18, which is.
No, did you tell them what date, or we'll just get a new date?
Oh, the next date, if it's for 30 days, and our next hearing is not until March 2nd.
All right.
Perfect.
Okay, Ben, good luck to you.
No, that's all right. Thank you very much. Have a good day.
You too.
The next case is item number 18, which is 1560 Coral Terrace Condominium. Case number is CEMHS 2022-00411. And this case was previously found guilty with an abatement date of January 12, 2023. Fine was set at $250 plus $100 cost assessment. The officer is Shannon Sanders.
Thank you. And who do we have here on behalf of the property?
We have.
Okay, I have hands raised, Milan Rodriguez and Farhan Abbasi.
Yes.
Thank you. If you're an attendee, just please, if you hear your case call, go ahead and hit the raise hand feature so we'll know to acknowledge you when your case is called. Milan, I'm sending you an invitation to join the meeting. Please accept. Farhan, I sent you an invite as well.
Good morning, everyone. Good morning, Special Magistrate. My name is Farhan Abbasi. I'm the General Counsel for the Condominium Association.
Thank you. Thank you, sir. Was there someone else that's supposed to be joining?
I had a Milan, Farhan.
I apologize. I think I heard the association name. I don't think this is for my case, so you can remove me.
Thank you.
Okay. All right. Go ahead, Mr. Sanders. Ms. Sanders.
Shannon Sanders, City of North Miami Code Compliance Officer. This is a case for property address 1560 Northeast 127th Street. Looking over it really quick, I just want to make sure, because I think we adjudicated this already. Yeah, it was. Okay. This is the case that's up for reports of previous compliance already been adjudicated. Upon my last reinspection on the 12th of January, compliance has not been met. Just to give you a quick refresher, this is a case that was originally cited after doing an annual housing inspection. I observed several cracks throughout the building. I met with a gentleman that identified himself, I believe, as the HOA president or assistant president or something to that effect, something I don't remember, but it was a gentleman that met and walked through the property with me, fully explained permits were needed due to the deep cracks as you're seeing in the pictures here. The building official has been out to the property. We've sent several emails fully detailing, explaining permits need to be obtained. Again, as of my last reinspection, the repairs have been made, some repairs, but the permits have not been obtained to make the necessary repairs. I'll let I think he said he's the counsel for the property, explain what's going on or why they haven't submitted the permits, what's going on. But, again, compliance has not been met as of the 12th of January.
All right. Mr. Abbasi?
Good morning. My understanding from what I was advised, so actually let me back up. I would have submitted some of this evidence, but the property manager at the association did not provide it until this morning. So obviously I wasn't able to comply with the January 9th deadline. But my understanding is that the contractor and the engineer have already submitted the plans. Miami-Dade County has approved the plans. They're waiting for the permit to pass final inspections. And there's a process number already with North Miami. The stuff I have from Miami-Dade County shows that there was approvals for 1, 2, 3, 4, 5 different process numbers as of the 18th of January, the 13th, the 12th, the 19th, and the 19th. So their previous issue was that their original engineer had essentially told them that he's not going to have time to do this. They then, after the last hearing, they had already retained a subsequent engineer who expedited his portion of the work. And what I was provided this morning, which I'm happy to share with everyone here, along with an email, is that they're just waiting for final inspections. A lot of the work was done, is what my understanding was, without permits, and they needed to then, after the fact, pull the permits with the engineering drawings. So I'm not sure if I can submit it or I can share my screen, but I have some PDFs here with everything that they did do.
Can you allow him to share his screen?
Magistrate, the concern is not that the repairs were done, is that it was done without permits. I was quickly looking to see if permits were, applied for, submitted to the city. I don't see anything in the application. So if he wants to give maybe those permit numbers that he's referring to, and we also have the building official here who has has been out there to the property, because I saw the deep gadgets in the in the concrete, and I just didn't look safe. So I'll let the building official even give testimony as to what he observed and why he's feeling permits are needed. But again, it's not so much the repairs, it's the permits that we're looking for to obtain.
Yes, Officer Murray.
Yes. Good morning. From the photos that Officer Shauna shared with me, it looks like structural repairs were done. It's not anything. It didn't give any indication of cosmetic repairs, but more of a structural nature. I don't know if he can provide. It seems like they submitted to the county, but didn't submit to the.
What I was told was that there was two different processes that they had to go after. One was with North Miami, and then one was with Miami-Dade County. So I have the receipt from November 8th, 2022, where they paid the $85 to North Miami. I have all the engineering drawings. I have the process numbers for Miami-Dade County, and I also have the process number for North Miami.
Yeah. What's the process number for North Miami?
North Miami, it says BB002022 00173.
It was, you said BB?
BB, yeah. To me, it appears to be two B's as in boy. But if you'd like, I could share the screen so you could see what I'm looking at.
That one, Mark, I'm showing here, that shows per that permit number, that's a repairs to a balcony. Seemed like a crack or something that was in a balcony that he's referring to for that permit number.
Okay. I didn't have a chance to pull it up yet, but that I don't believe that's issued, right? Is that issued, officer? Okay.
It has not been issued.
Okay. So we need that to be approved.
But that one just stands for repair a crack to a balcony, and this cracks throughout the entire building, as you see in the pictures depicted. This is more than just that one little area, because this is showing like it's 400 square feet of balcony space that they're repairing.
But it's more than that, yeah. From January, because the pictures that you showed were from May.
No, I actually showed you the most recent photos from our reinspection. I'll put them up again.
If you wouldn't mind.
I think, again, I just want to defer back to what the officer said. We're not debating whether or not the repairs have been made. The issue is that the violation, you were cited for cracks in a structure that was in disrepair. Repairs have since been made, but they've been made without the proper permits at this point. There's already been an adjudication on the item. Magistrate, as to not continue to prolong the matter, we're not debating whether or not they've made repairs. We're stating that at this time, they still have not obtained and come into compliance with the initial violation. I guess my question is to the building official. Is there, you guys are saying that, actually to the council, you're saying that there's a report that needs to be reviewed by our offices in order to get the permit, or where is the delay, or where is the issue in getting the proper permits to substantiate the repairs that have already been made?
My understanding, and I'm working off what I was advised this morning from the property manager, is that the contractor has submitted the plans. They were already approved by Miami-Dade County, and they're waiting on a permit to pass final inspections. But everything is moving forward on their end. He was apparently dealing with Miami-Dade County as well as North Miami. And that's why, I'm by no means a building expert, but I wanted to show you what I was provided, because a lot of the dating here is from January 18th, 2023. About fire inspection verification, and it shows the extent of the engineering drawings that speak to the entirety of the repairs.
Yeah, so with respect to fire and safety, that would be county. And so likely, whatever was necessary for them to obtain approval from the county has been satisfied. But I think what we're explaining to you is that as it relates to the permits from the city, there has been one permit applied for that applies specifically to a crack on a balcony. And the city's case is referenced cracks throughout the entire building. Again, they have started to make the repairs, but it appears as though there's another permit that needs to be applied for to address the structure in its entirety, and that is yet to be done. Magistrate, I think at this time, it's up to you. I mean, I'm going to suspect that, since they've made some progress, I don't know if this is necessarily where we would be concerned with an urgent safety matter. So I'm okay if you want to give another 30 days to have them come into the city and deal with the issue of obtaining the city's permits to address the repairs that have been made. But I think that the case has been, I think the case has been open since April of last year. So we're approaching a year on this matter. It's already been adjudicated. The repairs have been made. We just need them to come in and get the permits and, ensure that the inspections are done so that we can ensure that the repairs have been made and they're structurally sound.
Okay. I guess one last one for the building official. Is there anything in particular that you want within the next 30 days or the next couple of weeks?
Basically the issuance of the permit, if that can be done within the next 30 days, that'll be great, because that will kind of ensure that it's was properly examined by the engineer of record, and it's just a matter of that's the real thing I'm concerned about, the issuance of the permit. So that way they can do whatever corrections or to continue with their repairs.
All right. Can we do that? Can you put that as part of the reset, Madam Clerk? We'll reset for 30 days with the caveat that they do what the building official is requesting. All right. Everyone's clear?
My video.
Yes, ma'am. Thank you.
Yes.
Thank you, Mr. Abbasi.
Thank you, Special Magistrate.
All right.
Thank you, everyone from the city. I'll see you in 30 days.
All right.
We're going to proceed with item number 26, Coral Towers Condo Association, case number MHVIO 2022-00316. Any officers, Gennaro Murillo.
I have a Milan Rodriguez. It's your turn now, Milan.
That's me.
Can you enable your video, please?
Yes, ma'am.
Please raise your right hand. You solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth. If so help you God. Please say I do.
I do. Good morning, everybody.
Good morning.
So we have one.
I'm sorry, Ms. Rodriguez, just state your full name and relationship to the property, and then you can proceed.
My name is Milan Rodriguez. I am the property manager for Coral Towers Condominium.
Okay. All right, you can proceed.
We received several violations, 1, 2, 3, 4, 5, 6, 7, actually 8 violations in total from the inspector. We have complied with all of them. They were all, I believe, closed with the exception of the pressure washing of the building. We did contract the maintenance man and his company to do this for us. It should get done within the next week or so. So I don't really need a massive extension or anything. I just need maybe 2 weeks to just make sure everything is done properly.
Who's my officer on this? Is it you, Officer Morio?
Yes, Magistrate.
All right. So it says, am I correct that of all the violations is the
Yes, they have complied with other violations.
okay. And, all right. So are we asking to reset, give a 30-day reset, or what are we asking?
30 days is okay with me.
We're requesting an adjudication, Magistrate, with the 30 days. I can, I didn't show the photos, but I just wanted to mention to Ms. Rodriguez, I can show the photos. I think that pressure washing in certain areas might be adequate, but other areas need to definitely be repainted. I think that the building definitely has areas that pressure washing won't address.
Okay.
Yeah, so specifically like your stairwells, and I can show the photos so the magistrate can see what we're talking about. You've got, a whole lot of, the building needs more than pressure washing, I think.
Okay.
In terms of the, the issue as it's been citing, I think pressure washing is just, it's kind of one of these things that, hey, if you can pressure wash to address the matter, then do that. But if it's, if it needs to be painted, then do that. But whatever it is, just we want to ensure that the exterior conditions of the building are a little bit more aesthetically pleasing.
Understood.
Yeah, Magistrate, if take note that if it is paint that you decide to do on a commercial building, you will need to obtain a permit. Mm-hmm. So Magistrate, the city would ask to give her 60 days to address all of this, because it does appear she's going to need more than pressure wash with an adjudication on the matter.
All right. So based on the testimony and evidence presented, I find that the violation still exists. Hereby enter an adjudication and giving you 60 days by which to resolve the violation. If the violation is not resolved by the abatement date, there will be a daily fine amount of $350. All right.
Thank you. Thank you very much.
Thank you. Madam Clerk, before you call the next case, I need basically a 2-minute recess of a bathroom break.
Okay, so it's 11:08. We'll resume at 11:15.
All right.
Recording stopped.
Is everyone back?
Yes, ma'am, we're here.
Right, I'm gonna go ahead and proceed with
Hold on, let me resume the recording. Sorry.
Recording in progress.
Okay, if you can call the next case.
I'm gonna proceed with item number 32, which is HGMC Build LLC, case number MHVIO 2022-00701. The officer is Gennaro Murillo, and we don't have the property owner here, but the tenant is here.
Okay.
Person.
What? I'm sorry. What number was this again, Clark?
32.
Okay. Just in case, do I have anyone here in Zoom on behalf of this property? Right.
Good morning, sir. Please state your full name and relationship to the property.
Excuse me, my full name is Charles E. Brown, and I'm the tenant.
Okay, thank you, Mr. Brown.
Also, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
Yes, I do.
All right. Okay, you may proceed, Mr. Officer Murillo.
Good morning, Officer Murillo for the City of Miami. Code compliance. On November 9th, 2022, I opened a violation based on a complaint from Mr. Charles Brown from Unit 16, where I asked the property owner to exterminate his unit for rodents, roaches, and insects, and to provide an extermination report prior to the inspection date. They sent me an email where they stated that Mr. Charles Brown agreed on his lease that he signed that he was going to take care of the extermination. I opened the violation based on what the code says, that the landlord is in charge of doing the extermination. I contact Mr. Charles Brown, and he also came to the office because the property management company, they submitted a receipt where they said that they serviced the unit on November 10th. But Mr. Charles Brown came here with a report for two pest control company that he hired, and the report said that he still has the pest was not resolved in his unit. I notified the property owner, and I guess they don't want to. I asked them to get in contact with the company that Mr. Charles Brown hired, so we could get a response to them, letting us know that the pest was resolved. As of my final inspection, I had no answer from them, and Mr. Charles Brown said that he hasn't been in contact with them also.
Okay.
Still ongoing.
Okay, Mr. Brown?
Yes.
Yes, good morning, sir.
Yes, good morning.
Okay. What's going on in your apartment?
Well, I got like 3 infestations going on right now, and it's still ongoing. I'm still in touch with the pest control company that I hired to come out. I'm making all the payments to the pest control company. I've been calling the landlord, have not been able to get a response from her. And I'm now in over my head with the payments. And I'm still getting bitten up by fleas. And I'm a dialysis patient. I'm supposed to be at dialysis right now instead of being here, but right now I feel like this is the best place for me if I'm going to ever get into peace at home. And so I got a lawyer that prepared a statement, and she decides everything is still going on because I sat down and I talked with her, and I thought that I was going to come here today and then continue on to go to dialysis. But I would like to have you overlook the statements in the paper that she did for me, and so we can get this thing resolved, so I can get back to a normal life. I got a whole bunch of other medical issues going on, and I don't need this thing to continue in my life.
Okay. All right. And Officer Murillo, you said what's going on with notice for today's hearing?
Yes, I posted a notice to appear on December 22nd, and it was also mailed on December 29th.
Okay. And you have not had contact with the owners, and Officer Brown, you're indicating that you have not had contact with the landlord either, correct?
Yes, I've never had. I've called her several times, and she's rude over the phone, and she tells me she's not going to do anything. And then she just.
Is this a building, right?
An apartment complex.
An apartment complex with different tenants. Okay. All right.
Yes.
And this is the first time up. This has not been adjudicated yet, correct?
Yeah.
You wanted to add something, Ms. Patterson?
Yes, Magistrate, I just wanted to make mention, actually, we were in contact with the property owner, but once we notified her that she needed to further her efforts to remediate the issue, we had not had contact with her since. So they're well aware of the issue. They have not come into compliance, nor have, because we, again, just to reiterate what the officer said, we requested that based on the reports that Mr. Charles provided, that they utilize the same company and provide us a clean bill of health inside of the unit, and that has not happened. So, yeah, I think the city is requesting that you would enter an adjudication and a fine, as this appears to be more of a life, health, and safety issue from the city's perspective.
Okay. Based on the unrebutted testimony of the code enforcement officer and Mr. Brown, I find that the violation does exist. Also find good notice, given proper notice, the owner has failed to appear. I hereby find in favor of the city enter an adjudication. Owners have 30 days by which to resolve the violation. If the violation is not resolved within the 30 days, there will be a daily fine amount of $300. Okay. So, Mr. Brown, hopefully there will be an incentive for them to get it done. I looked at the photographs. I'm assuming this is just your apartment. I'm seeing, I saw roaches and I saw some other stuff that I don't know what they are. I don't know if they were ants. But it's unfortunate that you have to live in those conditions, and it's not okay. It's not acceptable. So hopefully, knowing that they will be incurring a daily fine, maybe then they will, do something about it, trying to alleviate, the current living situation.
Yes, I understand that, but I want to explain to you exactly what they were. They were termites. Termites fly out of the walls. They come and they land behind the furniture. They infect the furniture, so there's been damage not only to the apartment, but also to my furniture. And so, this is why I prepared this for you. And I would like for you to take a look at it from the lawyers, please, before you make a decision as to, because there's some damage done to all of my furniture.
That may be a separate legal action. I don't know, definitely not me as the special magistrate. And I don't necessarily know that whether or not the city can, get them to replace your furniture. That would probably be a separate legal action, but I'll let you talk to the city about it. But my ruling is really in terms of what's going on inside the apartment, just basically maintaining it and making sure that it's habitable, for you and the other tenants in the building. Okay?
Right. Okay.
All right, sir. Thank you. Have a good day.
You too. Thank you.
I'm going to proceed with item number 29 and 30. The officer is Shanna Sanders, which is Florida Trust Services, LLC. Case number CEBPR 2022-000737. And item number 30, case number CEBPR 2022-0757.
I have a Jose Jerez or Jerez here on behalf of this property. I apologize if I'm not saying your last name correctly.
It's okay.
Can you enable your video, sir, please, so we can swear you in?
Sure, give me 1 second. There you are. I'm just parking.
Please do.
All right.
Okay. Swear him in, please.
Sir, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? If so help you God, please say I do.
I do.
All right, Mr. Perez, if you can, I'm sorry, is it Jerez? I want to say it correctly.
Yes, Jerez.
All right. If you can please state your full name in relationship to the property.
Thank you.
That's Jose Jerez. I'm the property owner.
Thank you, sir.
Shanna Sanders, City of North Miami Code Compliance Officer. This is a case for property address 12655 Northwest 4th Avenue. Both of the cases are for building without permits. I'll start with the initial one that I first cited him for. While doing my normal inspections on early November, I'm showing here November 2nd, 2022, I observed some construction work that seemed to be going on. They were replacing or had replaced the fascia boards around the property. At that time, I spoke with a couple of gentlemen that were there doing the work. They called Mr. Jose on the phone, spoke to him through translation, explained to him that permits needed to be obtained for the fascia boards that were replaced. He, at that time, stated he didn't know that he needed them done. But however, I explained since the entire house had been had the fascia boards replaced, permits needed to be obtained. He stated he had permits that were, or applications that were being worked on, plans were being drawn up. He would be submitting them soon. Soon has come and gone. I have been monitoring the property. When I went to do the reinspection, I observed then windows that were replaced. I then sent a second notice to the property owner, which was the second violation, inquiring about the windows that needed to be replaced. Yet again, he stated plans are being worked on. They are being submitted to the city. Upon several re-inspections, I'm seeing more and more work that has been done. The entire house has had almost an entire renovation over the past 2 or 3 months. Per Jose again, permits are being worked on, plans are being submitted to the city. As of January 12th, no plans have been submitted to the city, and the whole house is almost complete with no plans at all. I'll let Mr. Jose explain what's going on, or if he recollects the conversation to be any differently. But compliance has not been met upon my last reinspection.
All right. Mr. Jerez?
Yes, ma'am. Your Majesty. Yeah, so I actually have permits I pulled for the violations that she was referring to. I could provide you the permits number, if I may.
Okay.
The permit numbers are BW. This is for windows and doors. Is BWD S0 2023-0018, and for the fascia board, permit number is BBR 00-2023-00035.
And you so okay, you
Oh, I'm looking. I'm sorry. I'm
No,
showing
it's okay.
they were issued actually this morning. I'm showing 126. That's why I'm looking over at if they were issued this morning. I'm showing here.
Okay, so both permits were issued. Go ahead, sir.
Correct. I'm sorry. Yes. I'm sorry, Your Majesty. One of them was issued yesterday. The other one was issued this morning. I actually went to when I actually went to pick up the permit. I went next door to the code compliance office, and they said there's nothing they could have done nothing about it at that point in time because it was too late within the day, and it's under the 24-hour time frame. So they just said just provide the permit numbers. That should suffice the issue.
Sir, I would say that it's not that there's nothing we can do. It's that we're bringing the case because you remodeled the property without permits. We're elated that you now presently have the permits, but the city would request that the magistrate still enter the adjudication so that we ensure that any future repairs, it's on record that, the property was remodeled at some point without permits. We're okay with not having any fines assessed and seeing as now you have come into compliance, but we do want the record to reflect that there was two occurrences in which remodels were made without proper permits to prevent any future occurrences.
No problem. Correct.
All right. Based on the evidence presented, I find that the violation did exist, so I will enter an adjudication. And I also find that the permits have since been issued, and therefore the owner is in compliance. So good luck to you, sir. Thank you.
Thank you. Have a good one.
Magistrate, just for record, clerk, I don't know if you're asking or you're clear or not. Are there any court costs assessed? There's usually a court cost.
Yes, court costs included. Adjudication plus cost.
That's for both cases?
Correct.
Okay.
So it's a guilty dismiss with $100 court cost, correct?
Yes.
Noted.
It's not dismissed.
Dismissed, right.
Yeah, it's adjudicated. There's no fine and there's but there is a court cost.
Mm-hmm.
Would I get an email or a letter?
You'll receive a
notice. Can I pay that?
You'll receive something in the mail.
Thank you very much.
Thank you.
I'm going to proceed with item number 39, which is NMB Partners, LLC, case number CEZCU 2022-00406. The officer is Christopher Colson.
Do I have anybody here on behalf of this property? Thank you. Tracy? Tracy, if you can accept the invitation to join the meeting. Thank you. If you would enable your audio and video, please.
Oh, hello. Can you hear me?
Good morning. Yes. Swear in, please.
Please raise your right hand, Tracy. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
Please state your full name in relationship to the property.
My name is Tracy Carvajal, and I work here at CMC Contractors, the tenant.
All right.
Good morning, Officer Colson, City of North Miami Code Compliance. I'm sorry. Case we're here in CEZCU 2022-00406. Certificate of use. We gave this case was originally opened 415 violations were found 2022. It was supposed to come to court. We gave an extension. Upon the request. And as a final reinspection on 1/12/2023, we still have violation still remains on this case.
All right. Ms. Carvajal.
I finally was able to get in touch with the architect and the GC because of the holidays. First one was out and then the other one. So actually yesterday they came by to just make some last minute changes to the drawings. And he told me within a week and a half, he should have everything completed. So an extension, I don't know how long you guys can give us. I know you've given us extensions before, but we're near the end already.
So where you're at right now, you're getting ready to
submit the
your plan?
drawings.
And
Yes.
this is to the city of North Miami, or you still doing the Durham process?
I'm not really sure, but he told me yesterday, he said in less than 2 weeks we'll be done and you could submit it.
Okay. Your Honor, I have no problem giving them 30 more days to submit. They have been in contact with me. I had talked to a different person, not her, when I went to the property, and they had been in contact with me, but I don't know what happened over the last.
I think I talked to you over the phone. We only talked on the phone. I don't think I was here in person yet.
Yeah, then over the last 2-3 weeks, I haven't had any contact, so I don't know what happened in that process. So I didn't have this part of the information.
Oh, sorry about that. That's my fault.
All right, so you're requesting a reset?
Yes, with adjudication.
Based on the evidence presented, I find that the violation still exists. I will enter an adjudication with an abatement date of March 16th. If the violation is not resolved by the abatement date, there will be a daily fine amount of $250.
Okay.
Good luck to you.
Thank you. Thank you, Colson.
You're welcome.
Item number 48, Waterstone Capital Holdings, LLC. Case number MHVL 2020000129. This case was previously found guilty with an abatement date of January 12, 2023. Fine set at $750 plus $100 cost assessment. And the code officer was Gary Beswick, and I believe Mark Jean will speak on this case today.
Is there anyone here on behalf of this property?
Acer Ferrero.
Okay. I'm just gonna swear I'm in, Mr. Building Official. Yes, sir. If you can enable your audio and video, please, so we can hear your case.
I'm here.
Right. I know you're here, but can you enable your audio and video? I mean, your video, please.
Let me see. Start video. Okay. I'm here.
Please raise your right hand, sir.
How you doing? Yes.
You solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth. So help you God. Please say I do.
I do.
Please state your full name and relationship to the property.
I'm Yasser Ferreira, representing Waterstone Capital.
All right.
Yes. On the 24th in the morning, I already got approved 100% everything. After that, the guys at the desk helped me expedite this a little bit with the financial department, and they already got the number. I went yesterday, but there's two of the contractors that liability insurance is already expired. So I already got all the paperwork here, and all I need to do is pay for my permit. That's it.
All right. Who's my officer on this?
Yes, I'm the. I'll be the one. Review, I guess, going through this case with for Vanessa. As which as I checked, as of today, they have not complied with the permit still in process, so they have not complied yet.
Okay.
I submit the evidence to your website.
He's showing that he has.
It's an electronic permit?
No, this is an addition permit.
Yeah, but you submitted through electronic?
No, in person. Everything has been done in person. Even Chief Jose helped me a lot. Miguel, everybody knows about this.
Okay. So
and then he's showing us a certificate. Where's the certificate that you were showing?
No, this is the email that you guys sent me with the amounts. It's just to issue the permit. That's it. It's been approved 100%.
Okay. So he just needs to come in to secure the permit.
That's it. Yeah.
When can you do that? When are you in a position?
Yeah, I couldn't do it this morning because two of my contractors has their license. It's been a year, so everything I submitted, it was already expired. So I got everything already. I can just go and get it. That's it.
Okay. Can you come can you come by I guess the end of next week to get the permit?
No, I can do it tomorrow in the morning.
Okay, yeah. Then come on down and get this thing.
Tomorrow morning. Yeah. I'm on top of it, but it's been, you know how contractors work,
Okay.
Okay. So what are we doing?
So hopefully if you could come, I don't know if we could put put a time frame for him to secure the permit, is a short time frame to ensure that he comes in to secure the permit. I don't know, Special Magistrate, what we could do.
Okay.
I'll be ready tomorrow for sure. Do
you want a 30-day reset?
Yeah, we can do 30-day. Yes.
Okay. Let's reset. Let's give it 30 days. All right. Thank you, sir.
Thank you very much. Have a good day, everybody.
You too. Good luck to you.
Item number 49, Wilner Peria, case number FYBRR 2019-0009. This case was previously found guilty with an abatement date of December 14th, 2021, and fine was set at $250. This case was by Gary Beswick, and Mark Jen will be presenting it today.
Wilner Perot here on behalf of this property. Sir, if you can enable your audio and video. Oh, here.
Is anyone here for this case?
Yes. Wilner, I'm sending you an invitation to join the meeting. You're going to have to accept it. Wilner, can you hear? Okay.
Unmute. Hi.
Oh, hi. How are you?
I'm blessed. Thank you.
Swear him in, please.
Daddy, raise your right hand.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
Please state your full name and relationship to the property.
Rochelle Perot, owner. Wilner Perot, owner as well. It's my dad.
Thank you.
Special Magistrate, this is a 40-year recertification that has not been, as of today, has not been complied with.
Yes, the last time we were on, we thought that we had to finish construction before we get the 40-year inspection, but you had explained to us that we could still get the inspection done, and whatever it is that needs to be done, they'll let us know, and that's exactly what we did. I wasn't able to send in the document prior to January 9th because we actually just got it on the 19th. But there are a few things that we have to do as you know, that we are under construction, but we did, we went with Milton Cubis. They came in and did the inspection, and we just have to make like a few changes and obviously wait. We have a permit that we're waiting on as well too, on the construction side for temporary power. I submitted that. the beginning, well, I think in December, and I'm waiting for them to approve that as well, so I could finish with everything. We're just literally just waiting for everything to come together.
And have you submitted your report, your report, even though it has deficiencies into the building department?
No, he hasn't. Milton Cubis has not given us the report yet. I had reached out to them like for a few, like back to back, but she said that the representative at Milton Cubis said it wasn't ready yet. She did provide me with this paper because I told her like, this is something that I need so I could, show that I did the inspection. She did provide, something to me letting me know that they did do the inspection, but she's still waiting on Milton to, I guess, go over the report so he can finalize it.
Okay. So, how soon are you thinking? What, in 2 weeks or so, or?
Yeah, I mean, I'm thinking, because we didn't have really much. We had to put like some exit lights, and we have like, I guess, like some bars on the outside that we're trying to, I guess, has to go underground. And we don't know if it's there or if it's not there. So we're just, trying to get that done. So I'm not sure if, I don't want to say 2 weeks in, but we are working on it though. We have an electrician that is working on the construction side that we're actually having check the bars and stuff like that they're requesting. And the exit signs on the inside seem to be fine. But also too, I do want to add that the side with the construction, the inspector did not look at it. He said that he cannot because there's no power there. So we did apply for the permit so we can get temporary power. We just haven't gotten an approval yet. So he still has to come in on that side, which would make the inspection not be complete because there's no power on that side.
Special magistrate, can we, I guess, give them 30 days to submit that report? At least that will take care of one component of the recertification.
All right. Okay. So we're reset for 30 days.
Okay. Thank you. All
right.
I'm working on it, Crystal.
Thank you.
All right.
All right. Good luck to you guys.
Thank you.
Thank you.
You're on mute, Madam Clerk.
We have an Anne Prosper in the queue. I'm not sure what case she's here for because she is not responsive.
Hi, Anne, are you there? Anne Prosper, are you there?
I'm there.
What property? What's your address?
13010 Northwest 7th Avenue, North Miami, Florida 33168.
Is that anyone's case? Anyone recognize the case?
Got it. It's item number 31.
Item number 31. Okay, and we're going to hear your case now.
Case item number 31, Gator 13090 Northwest 7th Ave, LLC. Case number CEFLR 202200249. And the officer is Christopher Colson.
Ms. Ann, we're going to ask you to turn on your audio and your video, please. Ms. Ann, are you going to join us?
Unmute.
Are you in the need of a Spanish interpreter?
I don't believe so. Here she is.
She speaks English and Creole.
Oh, okay. Sorry. The thing is that I received the invitation to get in. Okay, sorry.
Okay. Thank you. Unmute yourself, Ms. Ann.
Sorry, will she need an interpreter or will she continue in English?
We don't know.
I'm here. Yes, I'm here.
Okay, Ms. Ann, do you need an interpreter or are you okay?
No, I'm okay. Okay,
All right.
So speaking of which, magistrate, would you mind dismissing them?
At this time, I think that both our Spanish and our Creole interpreters, you guys can leave. Thank you for your service.
You're welcome. Have a great day.
Hello?
Yes. Swear, Ms. Gannon, please.
Yes.
Please raise your right hand, Ms. Ann.
Yes,
You solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth. If so, help you God. Please say I do.
I do.
All right. Thank you.
Good morning again. Officer Colson, Officer Christopher Colson, City of North Miami Code Compliance. This is a new case we're hearing regarding the business tax receipt. The case was originally opened on 4/26, properly mailed and certified. As of final inspection, the violation still remains. I did speak with Ms. Ann on yesterday, I think, and she's been in contact with our community planning and development, and they told her she was missing a paper. That's why she says that's what they sent me an email also saying what paper she was missing, a SunBiz, and that's why she was not able to ascertain her certificate of, a business tax receipt at this time.
All right.
But yes, ma'am. I had paid for it, but the problem is I didn't know that, the SunBiz was, expired. So I had paid for it last year. I haven't paid for it this year. I'm trying to get a little time just to pay the SunBiz that I can get everything back in track for 2023.
All right. Go ahead and work on that and get that done. We'll reset it. Hopefully that matter would have been resolved. If it is resolved.
Because the owner just delivered me the paper like less than 48 hours. So I didn't know about it. So.
All right. Okay. And how long you want it reset for, Officer Colson? Because I'm not here until April.
I'm not familiar with how long it takes to get the SunBiz part of it, so I'll at least give her 30 days on the reset. Because she has paid for it. I did see the pay for it part, and they confirmed that. And then she's just missing her SunBiz.
Okay.
Madam Magistrate, if I may, I just wanted to just put on record that the case has been open since April of last year. It sounds like what's happening is that the business owner does not have license with the state, the county, or the city. This is a daycare with children.
No, I'm not a daycare. I'm a clothing store.
Is this number 31 on the agenda?
Yes.
Yeah. It's a kids' clothing store.
Oh, kids' clothing store. I apologize.
Yes.
I apologize. Okay. We would just ask that if we're happy to give her whatever time she needs to square away all of her licensing, so she won't be able to get city without her overall, corporate licensing squared away. We would just ask for the adjudication, and then feel free to give her whatever time she needs, because she's going to need more than 30 days to get corporate license and city licensing.
All right. Okay. Based on the evidence presented, I find that the violation does exist. Enter an adjudication with an abatement date of 3/16. If the matter is not resolved by the abatement date, there will be a daily fine amount of $150. Ma'am, I'm giving you until March 16th. Okay? Get it done so that you can start, so you're not having to accumulate fines.
Okay.
Okay.
Thank you so much.
All right. Good luck to you.
Thank you so much. Have a good one.
You too. All right. We have no more. We have no one waiting, correct?
No, there's no more attendees.
But we do have how many items left on the agenda?
I would have to count them. In 1 second.
We're going
to take a break, Magistrate?
Yes, ma'am.
Okay. So weekend is 11:53. You want to do 12 o'clock resume? 5-minute break? It shouldn't take us too much longer. How many items are left, Peggy?
I don't need to count them.
We only had a total of 40 something cases anyway, so. Well, yeah. See what she said.
Also, Crystal, there was one where.
Hold on 1 second, Mark. Okay. 1 second. Go ahead, Peggy.
25 cases.
25.
That was not heard.
All right.
Yes.
Let's come back at 12:10.
Okay.
Mr. Mary, you wanted to add something?
Yeah, number 46. They reached out to me because I'm still looking at their 40-year situation. So. That one, I guess we can automatically table for give them some more time for number 40. 46. Sorry, 46. RK San Lucia.
Okay, you want to table number 46 for how long?
At 30 days. Hopefully we can resolve it in 30 days.
Okay, so number 46 is tabled for 30 days.
Okay.
Okay. All right. All right, guys, let's reconvene at 12:10, okay?
No problem.
Recording stopped.
Okay. Okay, I'll take a blueberry. Not that I can eat. I can't. Oh, I'm so sorry. I know. I started talking before.
I was trying to ping you. I thought you were on a call.
Greedy. No, I'm telling my associate to get me something to some
lunch.
Yeah. And some coffee.
All right, so I'm going to start the recording and so we can resume.
Recording in progress.
Magistrate number 44. Actually, it looks like there's two of them, Peggy, 44 and 45. I have a meeting set with the owners on Monday for these for this location. So we would just ask if we can just table those two items as well for 30 days.
Okay. So number 44 and 45, we're going to table for what?
30 days is fine.
30 days? Okay.
Yes, ma'am.
Gina, do you see where I put my gun? Well, it's Capricorn Nature's. Oh, okay. And do you know where I put my glasses? It's on you. Well, this one. Oh, the other one. You're persuaded to glasses around here. I don't open it.
Crystal, I'm going to make sure you said 44 and 45, but I know those are two of my cases. We're tabling those.
45.
Mm-hmm. Okay.
And I have some updates to some as well. Or how do you want to go through the remainder? And if there's something I can add?
Call them.
Yeah, she has to call them and put them on the record so that we can have a record as to what decisions were made on those cases.
Okay.
I mean, but you can have some stuff called out of turn if that's what you want.
No, I guess no. I guess she can go through the numbers. I don't want to throw her off.
Okay. If you want to be stuck with us here all afternoon, you can do that.
It's okay.
All right. That gentleman that sounded like he had the same name as Officer Perez, I was like, okay. And then I had to take a second look and say, oh, it's Perez. It's not Perez. Okay.
All right, clerk, you want to get moving?
Yes, I'm going to call. I'm going to call item number 7 and 15, which is for 12801 West Dixie Highway LLC. Case number for item number 7 is CEFOB 2022-00308. And then for item number 15, case number is CEZCU 2022-00533. And Officer Janelle Murillo.
Okay.
May I start?
Yes.
Good afternoon, Code Officer Murillo for the City of Miami Code Compliance. On April 28, 2022, I opened a violation to the property address 12801 West Dixie Highway for the unit on 727 Northeast 128. It was for a failure to obtain the business tax receipt. I had a reinspection on June 1st. There was no compliance. I posted the notice to appear on December 22nd. It was mailed on December 29th, and as of my final reinspection on January 12th, 2023, there was no compliance to renew the business tax receipt, which it was expired. The business tax receipt was expired on September 30, 2021.
Okay. Is this item number 7?
Yes, this is number 7.
Okay. Based on the unrebutted testimony of the court enforcement officer, I find that the violation still exists. You said the property was posted or certified mail?
Both. It was posted on December 22nd and it was mailed on December 29th.
Okay. I find that the violation does exist. Hereby find in favor of the city enter an adjudication. Owners have 30 days by which to resolve the violation. The violation is not resolved by the abatement date. That will be a daily fine amount of $250.
You need to do a record request or research.
And number
May I start?
15.
Yes, number 15.
So for the same property address, 12801 West Dixie Highway, a violation was open and mailed on April 28, 2022. It was for renew the certificate of use that was expired on September 30, 2021. A reinspection on June 1st, there was no compliance. Notice to appear was posted on December 22nd, 2022, and was mailed December 29th. As on my final reinspection, January 12, 2023, there was no compliance to renew the certificate of use.
Based on the unrebutted testimony of the court enforcement officer, I find that the violation does exist. Also find good notice, given proper notice. Owners have failed to appear. Hereby find in favor of the city enter an adjudication. Owners have 30 days by which to resolve the violation. If the violation is not resolved by the abatement date, there will be a daily fine amount of $200.
Now, item number 8 through 14, property address, property owner 12801 West Dixie Highway LLC. Item number 8, case number is CEMHS 2022-00350. This case was previously found guilty with an abatement date of December 2nd, 2022. Fine was set at $350 plus $100 cost assessment. Item number 9, case number is CEMHS 2022-00352. This case was previously found guilty with an abatement date of December 2nd. Fine was set at $350 plus $100 cost assessment. Item number 10, case number is CEMHS 2022-00353. This case was previously found guilty with an abatement date of December 2nd, 2022. Fine was set at $750 plus $100 cost assessment. Item number 11, case number CEMHS 2022-00354. This case was previously found guilty with an abatement date of December 2nd, 2022. Fine was set at $250 plus $100 cost assessment. Item number 12, case number CEMHS 2022-00358. This case was previously found guilty with an abatement date of December 2nd, 2022. Fine was set at $250 plus $100 cost assessment. Item number 13, case number CEMHS 2022-00359. This case was previously found guilty with an abatement date of December 2nd, 2022. Fine set at $150 plus $100 cost assessment. And item number 14, case number CEMHS 2022-00360. This case was previously found guilty with an abatement date of December 2nd. Fine set at $150 plus $100 cost assessment. And Christopher Colson is the officer.
Good afternoon again, Magistrate. The following cases are from an AHI inspection. They're all old cases. The first three, 350, 352, and 00353 are all dealing with the same thing, the meter room. You want me to present them all at one time, or you would rather me do them individually?
You can go ahead and present them at once.
The first three cases, CEMHS 2022-00350, CEMHS 2022-00352, and CMHS 2022-00-353 all deal with the meter room. Violations were open on the first one, 350, was open on 415. The other two were open on 413, properly mailed and certified, found guilty before. As a final reinspection with these three, I could not access the meter room. So I could not see had any work been done. So therefore, I failed the cases and put as violation still exists. I reached out to the owner, said he was going to arrange something for me to see inside the meter room. Never happened. So violation.
So you made contact, right?
Yes.
Okay, and they know that they have to call you for a reinspection, correct?
Yes. Yes.
And they said they were going to set something up, and they never followed up.
Yes, they didn't follow up for me to get into the meter room.
Okay. All right. Based on the unrebutted testimony of the code enforcement officer, I find that the violation still exists. The daily fine amount of $350. Let me make sure they're all $350. Let me see. Okay, number 7 is different. Number 10.
Yeah.
All right. So the daily fine amount of $350 as it relates to item number CEMHS 2022-00350. The $350 is ratified. Item number CEMHS 2022-00352. The fine amount of $350 is ratified, and case number CEMHS 2022-00353, the daily fine of $750 is ratified, and that's back to December 2nd, 2022.
You ready for the
proceed?
Okay. Next case, CEMHS 2022-00354. This is for window screens. And as a final reinspection, the violation remains. But he did contact me. He made contact. He said they were done. I did do a reinspection, and I saw the screens were in, but it was too late to remove off the docket. And that was today is Thursday. That was Tuesday.
Okay. So, all right. So that one is in compliance.
Yes.
Correct? Okay. So item number 11. All right. So if they're compliant, then this matter is resolved. So it's dismissed.
Yes. Next case, CEMHS 2022-00358. Extermination report. I have not, as a final reinspection, I have still not received this termination report. It was properly notified, properly mailed, and posted. I still haven't received this termination report as a final reinspection.
Okay. All right. Based on the unrebutted testimony of the code enforcement, and just for the record, the notice for this hearing is as you testified earlier, correct?
Yes. Was open on 4/13. The violation was open on 4/13, properly mailed out 4/15/2022.
I'm sorry, you said
that was that. That's 4/13, and as a final reinspection of 1/12/2023, the violation still remains, and they were properly notified for the hearing.
Okay. Based on the unrebutted testimony of the code enforcement officer, I find that the violation still exists. Also find good notice, given proper notice, owners failed to appear. The daily fine amount of $250 is hereby ratified, retroactive to December 2nd, 2022.
Next case, CEMHS 2022-00359. Again, this case has a final, let's do this. Violation was open 4/13/2022. Was properly mailed out as a final reinspection of 1/12/2023. the violation still remains. This was another one. He reached out to me. We did inspection on Tuesday, and the mailboxes have been completed. They have been fixed.
Magistrate, we would request that you would still adjudicate on these matters. The compliance has been met, so that we can kind of just keep it on record for any future issues.
It's already adjudicated.
That was adjudicated?
Yes.
Yes.
All the cases have already been adjudicated. It's just a matter of whether or not they're in compliance or not. So as for item number 13, CEMHS 2022-00359, you're saying that they made the repair to the mailboxes, so that one is complied with?
Yes, that's what it's complied with.
So basically, with the cases that are in compliance, I think the only thing that, the city is left to do is collect on the court costs.
Assessment, right.
Okay. All right.
So the one that you dismissed earlier, I think we did a dismissal. I think we would be closing it for compliance versus dismissing it and assessing the court costs.
That would be
understood. Yes.
That'd be CEMHS 2022-00354. That was the.
That's correct. That's correct. So I stand corrected. Okay.
And the final case is CEMHS 2022-00360. That was for contact information. He also has complied with that and placed the contact information up. But as a final inspection, the violation still had remained on 1/12/2023. But he's in compliance as of Tuesday just passed.
Okay. All right. So basically, for this one, it's closed for compliance, but we still have the cost assessment that's outstanding.
Yes.
Correct?
Correct.
Okay. All right. Thank you, officer.
Thank you.
With item number 23, Centennial Law Group LLC, case number CEBPR 2022-00513, and the officer is Jose Perez.
Good afternoon. Good afternoon, Officer Perez with the City of North Miami. Today we're hearing the case in regards to the property at 2095 Northeast 121 Road. This in regards to work without permits, specifically seawall altercations. They installed some glass railings on the seawall that were done without permits. The property was originally cited back in May 2022, and they were given until May 24, 2022 to obtain permits. However, they did not obtain permits. The original violation was sent via certified mail on Wednesday, April 27, 2022. The notice to appear was posted at the property and sent via certified mail on Monday, January 9th, 2023. At this point in time, there still have not been any permits obtained for the work that occurred on the seawall. At this point in time, we're also seeking an adjudication and daily fine until compliance has been met.
It's the first time, based on the unrebutted testimony of the code enforcement officer and the evidence presented, I find that the violation does exist. I also find good notice, given proper notice, owners have failed to appear. Hereby find in favor of the city enter an adjudication. Owners have 30 days by which to resolve the violation. If the violation is not resolved by the abatement date, there will be a daily fine amount of $250.
Item number 27, we have Église Évangélique des Pèlerins, case number SDNOV 2022-00626, and the officer is Shannon Sanders.
I'm sorry, which case did you say we're on?
27.
Of church. Shanna Sanders, City of North Miami Co-Compliance Officer. This is a new case for property address 1293 Northwest 119th Street for violation of our sanitation ordinance. I received an email from our sanitation clerk informing me that Waste Pro informed her that the property was not in compliance with the sanitation services that the city requires. I made contact with the property owner in May regarding this violation. We had several conversations. As of my last reinspection on January 12th, compliance has not been met. The property owner has failed to maintain the proper sanitation services that the city requires. He does not have a dumpster at the commercial property that he occupies. I am showing proper service was given. I posted the property with the notice to appear, as well as hand delivered it to the pastor. We've had several conversations, so he is fully aware of the violation.
All right. Based on the unrebutted testimony of the code enforcement officer, I find that the violation still exists. Also find good notice, given proper notice. Owners have failed to appear. Hereby find in favor of the city, enter an adjudication. Owners have 30 days by which to resolve the violation. If the violation is not resolved by the abatement date, there will be a daily fine amount of $250.
Item number 28, Emerald Investment Properties LLC, case number RCCOR 20200006. This case was previously found guilty with an abatement date of November 10th, 2021. Fine was set at $150. The officer is Gary Beswick. Mark Jean will be speaking on this case today.
Good afternoon again. This is Mayor Jean, building official. And also, can you give me the number? Sorry, the number? 28. Okay, so with this case, the permit, there was a permit that was issued on November 17, 2022. But there is still a permit that's still in process, and the REOC is still pending. So it has not been complied with.
And
the notice was notification was posted on January 6, 2023 at 3:48 p.m. So they were notified of the appearance for court.
Okay.
Yeah.
So they're still missing some steps to get
Yeah. They still need to, yeah.
Okay. All right. Based on the unrebutted testimony of the code enforcement officer, I find that the violation still exists. Also find good notice, given proper notice. Owners have failed to appear. The daily fine amount of $150 is hereby ratified, retroactive to November 10th, 2021.
Thank you.
Madam Clerk, you're on mute. Madam Clerk, you're on mute.
Sorry. Item number 34, iGlobal Trading Inc., case number CESCA 2022-00055, and the officer is Jose Perez.
Officer Perez with the City of North Miami. Today we're hearing the case in regards to the property at 14951 Royal Oaks Lane, unit specifically 2109. This is in reference to short-term advertisement. The property was originally cited back in May 4th of 2022. They were advised that the advertisement that will remain online is not allowed. They were given until May 13, 2022 to remove the advertisement, which they did not. As of my final reinspection, the advertisement remains online. And the property was noticed on January 9th, 2023, both via certified mail on posting for the hearing. At this point in time, the city is seeking an adjudication and a daily fine until compliance has been met.
So sorry. I'm sorry. I think this is, I think our provision is only specific to single family. This is a condo unit, which I don't believe is subject to our provisions. I didn't catch this in the agenda review, but I think we would have to dismiss this item, Magistrate.
All right. Item dismissed.
Item number 35, Jose Antonio Iglesias Alamin, case number MHBI 0202100057. This case was previously found guilty with an abatement date of January 12, 2023. Fine was set at $500 plus $100 cost assessment. Mayor Jean will be speaking on behalf of this case.
Hi, good afternoon, Mayor Jean, a building official. Special Magistrate, a notice was posted on January 6, 2023 at 4:08 p.m. And also, they look like they're making some effort to resolve the issue. They have gotten their electrical permit, I believe, for the mini split was already issued, and they have submitted for the windows on January 9th, 2023. So it's still in review. So I don't know if we'd be able to give them, I guess, at least 30 more days. And hopefully by that time they can get the permit.
Okay. You think 30 days is going to suffice?
Yeah, it for the windows, I believe it's just one more review in order to complete the review process. Hopefully they can get that approved.
Okay, we said 30 days.
Okay.
Item number 36 and 37, might be pronouncing it wrong. It's Wuga Investments LLC. Case number CEXP 2021-00013. And item number 37, case number CEMIS 2021-0040. And the officer is Shanna Sanders.
Shanna Sanders, City of North Miami Co-Compliance Officer. Both cases are for property address 12165 Northwest 2nd Avenue. The first case that I am going to present is for CEXP 2021-00013 for the exterior walls that are unmaintained. The property was initially inspected November 20th of 2021, whereas a notice of violation was mailed out to the property owner via certified mail. I followed up with a second notice of violation October of last year. Had not had any contact with the property owner as of my last reinspection on January 12th. The violation still remains in need of some pressure cleaning, some repairs. The exterior walls
Preston, do we have the pictures?
The exterior walls are, chipped with paint. There's a little rust and mildew, things of that nature. I have not had any contact with anybody. I am showing proper service was given. We mailed out certified mailing and posted the property as well. You see the mildew and dirt stains on the fascia boards and trimmings on the side of the house. There's some chipped paint, more rust and mildew dirt stains.
Got it. Want to open my file. Okay, so you said that it was previously adjudicated. Let me check.
No, this is a new case. This was a case. It's been pending for some time.
Okay. So 21, I see.
Yeah, 2021, but no adjudication has been met. It was kind of lost of our system with, different positions changing around. So I followed up.
It hasn't been heard yet, Magistrate. Yeah. Thank you, Shanna.
Okay. Based on the unrebutted testimony of the code enforcement officer and the evidence presented, I find that the violation still exists. Also find good notice, given proper notice, the owners have failed to appear. Hereby find in favor of the city enter an adjudication. Property owners have 30 days by which to resolve the violation. If the violation is not resolved by the abatement date, there will be a daily fine amount of $350.
The second case that I have is for the exterior of the property, being more so the frontage, same address, 12165 Northwest 2nd Avenue. The frontage is in need of resodding, as you see depicted in the pictures. Grass area is, damaged. Needs of the TLC. The violation was originally cited on the same date, being November 20 of 2021, whereas a notice of violation was mailed out to the property owner. I followed up with another second notice of violation in October, posted the property December. Last reinspection, no compliance met. I am showing that proper service was given. We certified, mailed the notice, as well as I posted it, the property as well.
Based on the unrebutted testimony of the code enforcement officer and the evidence presented, I find that the violation does exist. Hereby find in favor of the city, enter an adjudication. Owners have 30 days by which to resolve the violation. If the violation is not resolved by the abatement date, there will be a daily fine amount of $100.
And so you said $100 or $150?
$150.
Item number 38, Louis F. Berna. You pronounce the last name. Case number CESTA 2022-00073, and the officer is Jose Flores.
Good afternoon, Officer Perez with the City of Miami. Today we're hearing the case at property 12448 North Bayshore Drive. This is in reference to a short-term rental advertisement in a single-family home. The property was originally cited back in August of 2022. They were sent via certified mail. The notice violation depicting on August 26, 2022 deadline for compliance. That compliance date passed and they did not remove the advertisements. As of my final reinspection, they still have the advertisements up and active, and the property was posted for the hearing on January 9th and was also sent via certified mail. At this point in time, the city is requesting an adjudication as well as a monetary fine for not being in compliance.
All right. Based on the unrebutted testimony of the code enforcement officer and the evidence presented, I find that the violation does exist. Also find good notice, given proper notice, the owners have failed to appear. Hereby enter an adjudication. Owners have 30 days by which to resolve the violation. And if the violation is not resolved by the abatement date, there will be a daily fine amount of $350. Well, let me strike that. I was doing $500, so let's make it $500. That's what I issued in the, well, this is not a repeat. I'm sorry, Officer Perez. You didn't testify that this is not a repeat? Okay, my apologies, Madam Clerk. We will keep it at $350.
Item number 40 and 41, we have, just item number 40. North Miami Storage LLC, case number CEZCU 2022-00459, and the officer is Gennaro Murillo.
Good afternoon, Officer Murillo for the City of Miami Code Compliance. On April 25th, 2022, I opened a violation to the property address 640 Northwest 133rd Street for Life Storage LP for not renewing their certificate of use, which was expired on September 30, 2021. I had an inspection on May 31st, 2022. There was no compliance. A notice to appear was handed in the front of the front office on December 27, 2022, December 29, 2022, the notice to appear was mailed. I had a final inspection on January 12, 2023, and there was no compliance.
Okay. All right. Based on the unrebutted testimony of the code enforcement officer, and that the violation does exist, also find good notice, given proper notice, the owners have failed to appear. Hereby find in favor of the city, enter an adjudication. Owners have 30 days by which to resolve the violation. If the violation is not resolved by the abatement, there will be a daily fine of $250.
Item number 41, North Miami West Holdings LLC, case number CEZCU 202200449. The officer is Gennaro Murillo.
On April 25th, 2022, I opened a violation to the property address 1555 Northeast 129th Street for L&M Apartments for not renewing the certificate of use that was expired on September 30, 2020. I had a reinspection on May 31st, 2022. There was no compliance. A notice to appear was handed to Valerie on December 22, 2022, and a notice to appear was mailed on December 29, 2022. I had a final inspection on January 12th, and there was no compliance.
Based on the unrebutted testimony of the code enforcement officer, find that the violation does exist. I also find good notice. Given proper notice, the owners have failed to appear. Hereby find in favor of the city, enter an adjudication. Owners have 30 days by which to resolve the violation. If the violation is not resolved by the abatement date, there will be a daily fine amount of $250.
Item number 43, which is Partners of 822 LLC, case number CEVCU 2022-00433. Oh, sorry, that one is in compliance. I called that earlier.
Okay, I was about to say, why do I have that crossed out? Okay.
Let's see.
I think item number 47 we have not heard.
Yes, item number 47, Washington Mutual Bank, case number CEZCU 2022-00445, and the officer is Gennaro Murillo.
On April 25th, 2022, I opened a violation to the property address 12600 Northeast 7th Avenue to JP Morgan Chase Bank for failure to renew the certificate of use expired on September 30, 2021. I had a reinspection on May 31st, 2022. There was no compliance. A notice to appear was handed to Cynthia on December 27, 2022. It was also mailed on December 29. I had a final inspection on January 12, and there was still no compliance.
Based on the unrebutted testimony of the code enforcement officer, I find that the violation does exist. I also find the notice, given proper notice, owners have failed to appear. Hereby find in favor of the city, enter an adjudication. Owners have 30 days by which to resolve the violation. If the violation is not resolved by the abatement date, there will be a daily fine amount of $250. This is everything that I have.
That concludes our agenda. Thank you.
Thank you. We are adjourned.
Thank you.
Thank you. Have a good day.
You too. Bye, guys.
Recording stopped.
Bye, everyone. Bye, magistrate.
Bye.